Hi all, I'm Dan Smigrod, founder of the We Get Around Network Forum. Today is Thursday, August 6th, 2020, and you're watching WGAN TV live at 5. Our topic today, Matterport Service Partners, class action lawsuit against Matterport. And our guest today, my guest is one of the plaintiffs' shared co-counsel, Tom Zimmerman, with Zimmerman Law Offices PC in Chicago. Hi, Tom. Good to see you.
Hi, Dan. Good to be here.
Thanks for being on the show today. I think for our viewers today, I think part of the takeaway that I'd like to have them experience is why did two Matterport service partners, MSPs, file class action lawsuits against Matterport? What do they say Matterport promised and failed to deliver? What do they hope to gain as a result of their lawsuits? And what was the Illinois lawsuit and why was that dismissed in favor of refiling as a class action lawsuit? Tom, how about taking us back to the beginning and just give us a little bit of an overview?
Sure. So a gentleman named George Kenner filed a suit in California back in July of last year. And he sued on behalf of a class of California MSPs against Matterport. We then filed in Illinois with John Stemmelin as the plaintiff on behalf of a class of Illinois MSPs, and that was in December of last year. Matterport then moved to dismiss the Illinois case, and in their papers they argued that there were various contracts, terms and conditions that govern the MSPs and their relationship with Matterport. And those contracts required any lawsuits to be brought in California court. That's called a forum selection clause. And so we agree. So we voluntarily dismissed the Illinois lawsuit and filed it in California federal court, still as a class action. But this time we expanded the scope of the class to be a nationwide class action for all MSPs throughout the country, excluding California. And the reason is there was already the Kenner complaint that sought to represent a California class of MSPs, and we didn't want any overlap with that. So we filed against Matterport and several of the directors individually. They're also named defendants. And that brings us to where we are now.
Terrific. Thanks for the overview. Tell me about, so there's two different complaints. Perhaps we start with the one that you originated in Illinois. What is it that the plaintiff, your client, is alleging that Matterport violated?
Right. So the attorneys in the law firms are co-counsel now in both cases. I'm counsel for George Kenner now in the California case, and his lawyers are co-counsel with me in the newly filed Stemmelin complaint in California federal court. Both complaints allege generally the same allegations as pertaining to alleged misrepresentations and omissions by Matterport and its agents and employees. Generally, the complaints allege that Matterport had promised that MSPs would receive pre-qualified filtered leads for their local geographic area. And they would get so many of these that it would pay for the initial investment in the hardware, building the website and all the other things an MSP had to do, such that they would recoup their initial investment relatively quickly. The problem with that, that Mr. Kenner and Mr. Stemelin have experienced, and that we've heard from others, and as is alleged in the complaint, is that Matterport would saturate the local geographic area with MSPs, and they would be competing over the same leads. So it was very difficult for an MSP to get the business, number one. Number two, if they were able to get some business, essentially they were competing with fellow MSPs in their same geographic area. And that was something that was not disclosed to them, that this would be occurring. And so that's one of the misrepresentations or omissions that are alleged in the complaint. Additionally, their experience was that Matterport had represented that scanning was easy, that it was easy for anybody to get started quickly, that Matterport would provide the MSPs with training and resources. But in reality, the plaintiffs in these cases found that there were very large upfront costs, purchasing of the camera, of tripods, of ancillary, iPad or computer, setting up a website, all the insurance that went along with it. There were a lot of upfront costs, and it took a long time to learn how to use the equipment. And in their experience, Matterport provided very little training, such that they and other MSPs were relegated to actually serving as a peer-to-peer technical support team for each other, because they weren't able to get the initial technical support that they were promised. And so they looked to each other, other MSPs who were in the same situation, and essentially self-taught each other. And that is alleged in the complaint.
So what of the examples that you've provided, what laws would these violate that you've stated in the complaints?
So currently, there's the California Unfair Competition Law and the California False Advertising Law. Those are statutes. Those laws would apply because there is a choice of law provision in the Matterport terms and service that states not only do California courts have jurisdiction to hear legal matters, but that California law would apply. So these California statutes would apply not only to the California class, but also nationwide, because all of the MSPs are subject to the terms and conditions of those agreements, and so is Matterport. And so therefore, the California statutes would apply regardless of what state you're in. And they're generally statutes that prohibit unfair conduct, fraudulent conduct, misrepresentations, omissions. So things that somebody should tell you, but failed to tell you. And had you known of it, it would have made a material difference in your decision making. All of these are encompassed within those statutes. And that would apply to those examples that I gave you. There are other examples in the complaint. One of the other allegations is that the cameras save the images in a format that's unreadable unless the purchaser also subscribes to the Matterport cloud service plan and pays a monthly fee. If they were to drop that plan and no longer subscribe to the cloud service plan, then they lose access to their images and the models that they've created. And Matterport would retain them and still have access to them, but the MSP who developed it would lose access. And the plaintiffs allege in the complaints that that was not made clear to them, that if they were to leave or if they were to not participate in that particular plan, essentially they would lose access to everything and all the work that they've done. And there's another issue that is somewhat recent, and that is that Matterport is setting up a new program, the Capture Services Program. Essentially, the allegation is that Matterport is competing with its own MSPs. And if an MSP were to be fortunate enough to be accepted into the Capture Service Program, they would have to be subject to a non-solicitation clause in the capture technician contract that prevents them from servicing existing customers directly, and for a period of, I believe it's 24 months after that contract terminates. So the plaintiffs and others that we've talked to feel that they were deceived when they enrolled in the MSP program for these reasons, and there are others alleged in the complaint. And those would tie into the two consumer fraud statutes that I mentioned, the two California statutes. There's another aspect to the case, and that is a multi-state aspect for 21 states, not including California. If you add in California, it's 22. And they have disclosure requirements. So when a company sells a business opportunity, and we allege that the MSP program falls under that definition of a business opportunity, that there are certain statutes that govern that. And those statutes require disclosures. They require written contracts be provided by the company to the prospective purchaser ahead of time, that the purchaser be given some time to review those agreements, and that the purchaser also be provided with written disclosures that they could then consider in determining whether they want to enter into this business opportunity. And some of these disclosures require, and I could just read off of this, names and addresses of the salespersons who will engage in the offer or sale of this business opportunity within their state. Prior business experience of the seller relating to business opportunities and a description of their experience for the last 10 years. A listing of educational and professional backgrounds for the seller, whether they've been convicted of a a felony or been subject to any criminal or civil or administrative proceedings alleging a violation of any business law, whether they've been bankrupt within the last 7 years, the initial payment that's required, a description of the actual services the seller agrees to perform for the purchaser, a description of any training the seller agrees to provide, any representations by the seller to the purchaser concerning sales or earnings that may be made from the business opportunity, a copy of the most recent audited financial statement of the seller that was prepared within the last year, a list of states where the business opportunity is registered.
Excuse me, Tom. So for context, I think what we're talking about is both complaints include at the highest level of violation of the seller assisted marketing plan laws. And that's what's in the 22 states.
That's correct.
The 22 states specify seller assisted marketing plan laws have been allegedly violated. Why do both plaintiffs feel that way? Is there perhaps you could read maybe a little bit from the complaint about the promises they felt were made regarding being able to recoup costs within 6 months?
So with respect to these seller assisted marketing plan or business opportunity sales laws, they require generally, and each state varies slightly, that the seller, in this case Matterport, would have to register their business opportunity, in this case the MSP program. They'd have to register that with the state, and they would have to provide the state with the disclosures, the disclosure document that they're going to be providing to these prospective purchasers. We issued Freedom of Information Act requests to all of those states. And in every instance, it came back that no such registration was on file. So in other words, the state was telling us Matterport had not complied with the requirement that they register the MSP program and that they provide the copy of the disclosure form. The statutes are very explicit in their intent, and that is to protect the public from people selling these seller-assisted marketing plans. It's to protect the public, to provide them with information so that they can make a determination as to whether other representations that are being made, either on the seller's website or over the phone, if they're talking to a representative of the seller and they're making representations to them over the phone, they'll have the written disclosure document where they can verify whether those representations are true or whether there are other things in the disclosure that the seller is not putting on their website and not telling them over the phone.
Do you think regarding both complaints where there's alleged violations of seller-assisted marketing plan laws, where you've determined that Matterport did not file in those 22 states seller-assisted marketing plan registrations, whatever that might be, do you think Matterport would argue, no, we were not doing a seller-assisted marketing plan. We were simply selling a camera, a cloud platform, and photographers were free to, pay for a camera, pay for a cloud plan, and go out and market. And that Matterport did not make any claims that that would be construed as a seller-assisted marketing plan.
Well, they would have no choice but to argue that. If they did not comply with those laws, then their only defense would be the laws did not apply to them. And so that'll be a legal determination that'll be made either by the judge or the jury. And there are a number of factors set forth in these statutes that you would look and see, all right, does your MSP program make this promise? Does it meet this factor? And you would tick them off one by one, and there would be a determination made as to whether or not they did fall within the definition of the seller-assisted marketing plan or business opportunity sales law for each particular state. We believe they did.
I'd like to just share my screen for a moment and go take a look at one of the complaints. This is this is John Stemlin's complaint. If I go here on page 5, it says that Matterport's website, formerly located at this particular website address, stated your business your way, quote, be your own boss, set your own hours, and earn what you want for only $4,100 in upfront investment and minimal training. You'll be on your way to a lucrative self-owned business. Is that the example that you feel applies, excuse me, to this seller-assisted marketing plan law? Is that an example?
It is, and the statutes are very specific in what they require in order to fall within the definition of a business opportunity. And so there are a number of examples throughout the complaint. That's one of them, as to what factors would be satisfied under the particular statute that, in our opinion, the MSP program would then qualify as a business opportunity under the definition in the statute.
My challenge when I went to look at that Matterport URL, it's not there anymore. Do you have copies of these documents?
We do, yes. Yeah,
And
we researched thoroughly factual allegations before alleging them in a complaint. And if we're citing to a document, we've seen the document. If it's a web address, we'll take screenshots of the web address.
Okay, I'm going to go back, if I may just go back to the document, because there's another, excuse me. This would be on page, I guess it's the page 2, and I'm just searching on the word months. I think I'm in the right place. Matterport inside sales representatives falsely represented to potential buyers that MSPs receive marketing materials and filtered leads in their geographic 3 to 30 mile location that would pay for the initial investment in the Matterport 3D camera in 6 months. So that's an example of a document that you have from Matterport that you feel directly addresses this seller-assisted marketing plan laws that Matterport has allegedly violated by not filing that they are in fact a seller-assisted marketing plan company. Is that the way to say that?
So if we don't cite to a document, then it's not based on a document. This particular allegation is based on the experience of the plaintiffs who were told this from the representative.
Okay, so is this a he said, she said kind of conversation?
Well, I presume based on my experience litigating for over 20 years in commercial class action litigation, they will have a script. Sales representatives have scripts that they read off of. And if the two plaintiffs heard the same thing on different phone calls from different sales representatives, then we're pretty sure that through discovery in this case, we'll be able to obtain all of the scripts that they were reading off of. And at that point, we'll have a document that will show that this was a standard script and standard representations that were being made to everybody. That's why we allege in the complaint on information and belief, these same representations were part of a standard script that was communicated by Matterport. It's for that reason.
Mm-hmm. Going back to the Matterport Capture Service Program, that's something relatively new this year, did not exist at the time that either photographer bought the camera. Things change?
We don't know when these things changed or what their intent was. I know that there was a prior interview on your show with a Matterport representative talking about insurance companies and how they had things planned. It sounds like they were referring to this capture services program, but it's hard to know for sure. We don't know how long ago they had this Matterport Capture Services program planned and how long it was in development. It didn't just happen, overnight. And any of the MSPs, the service partners who became service partners after Matterport was developing this capture services program, certainly would want to know about that and would want to know why didn't Matterport tell them when they were contemplating becoming an MSP and spending the money and all the initial investment, that at some point in the future, things were going to change and the opportunities were not going to be there for them like they had thought, because they were developing this new program and other people would be getting those leads in that business. I would certainly want to know that.
Could you speak a little bit more? It's addressed in your filings of what is it about the Matterport Capture Service Program is competitive to Matterport service providers?
So I don't have a full understanding of all of the aspects of the Capture Services program. It's relatively new. It came out this year, I believe. And so we're still investigating all of the aspects of it. My understanding is that if you want a particular job, that you and it falls within this program and whatever the requirements are for the program, that would be farmed out to these capture technicians. It's a different group of folks, and the capture technicians would get that work. An MSP would not get that work. And so if an MSP wanted to become a capture technician, And I believe it's discretionary on the part of Matterport to decide whether to accept you into that or not. Then they would not be able to service their existing customers directly anymore. They couldn't go to them because there's a non-solicitation clause in this agreement. So we have just some sketchy information about it. We don't know specifically all of the terms. It was not announced at the time we filed our complaint, so we don't have any allegations about this particular program in the complaint, but it's something that we're looking into.
So correct me if I'm wrong, but at a top level, I believe what the plaintiffs are alleging is that, hey, buy a camera, get a cloud platform, you'll start a business, we'll send you leads, we're going to help you succeed. And then all of a sudden Matterport comes out with the Matterport Capture Services program and says, hey, large companies, if you need scanning done across America, place one order at one price, and we'll service that to make it easy for you to place an order. And we'll go to the Matterport Capture technicians to fulfill those Matterport scans. And so I think just to kind of tie it together, your complaint would be, hey, you're telling us you're setting us up in business here, but yet you're competing with us.
Well, that's the way it appears to be from what little we know about this new program. It appears to be that these big customer leads are not going to the MSPs. The MSPs are getting bypassed, and Matterport is handling those in a different way.
So it may be two things. One is the photographer is not getting the lead, and two, it's actually going to someone who has agreed to be paid at whatever rate Matterport determines for that business, which may or may not be your plaintiff. So they bought a camera, they're out scanning, and then all of a sudden Matterport may be competing with them for the same client.
It appears that's what's happening, but we don't have all of the facts yet to make any allegations or anything definitive with respect to any statements or allegations in a complaint on that at this point without further discovery. It's still too new of a program that I don't want to comment on that at this point.
Okay. So going back to the two other alleged violations in the complaint, unfair competition law, false advertising law, was there anything else in terms of what you felt was unfair competition? Again, I presume the Capture Services program might be considered unfair competition. Was there yet something else that might be considered unfair competition?
No, I think we've generally covered it.
Covered it. So saturation of selling more cameras into a market than perhaps there are opportunities.
That's certainly part of it, yes.
Okay. All right. So I know that piece that we read, or I read from the complaint, talked about a $4,100 camera, but I noticed in the complaint that your client, the plaintiff, John Stemelin from Illinois, talks about an investment that exceeded $22,000. That was with two Matterport cameras, presuming some other related gear, etc. And that if we did the math on the 230 members in the class that were, I guess, identified, that comes out to more than $5 million is that $5 million what you're seeking?
So there's I don't know, I haven't got my calculator in front of me, but there are a number of remedies that are available under the different statutes. One of them is contract rescission. So if an MSP feels that they were deceived and they don't want to be part of the program anymore, they can cancel their contract and not be bound to the terms. We would seek under the statutes the various remedies that are provided. One of which is they would get a refund of all the money that they paid. I mean, they could return the camera, get their money back. Any actual damages that they've sustained with respect to website hosting, insurance, the tripod, any other ancillary products or services that they purchased, they would be entitled to recover that. And some of the statutes provide for penalties. So some percentage, an additional 10%. Some provide for treble damages. So the MSP, let's say they're out $20,000. The court would triple that, and they would get 3 times their damages in order to punish Matterport and to deter other companies from engaging in similar conduct if that's what the court found to have occurred in this case.
So in the case, it's helpful for me just to visualize one person in this conversation. So if we talk about John Stemlin and his investment was $22,000, as he's calculated it for 2 Matterport cameras, presumably there's some iPads, tripods, related gear, his Matterport cloud hosting, maybe he ordered floor plans. Somehow he got to a number of 22,000. If the court found in his favor, then he might get to be able in the contract rescission, the ability to send all that stuff back to Matterport and maybe get interest on top of that and maybe get triple damages awarded. So that 22,000 turns into 66,000 or more.
Correct.
And
under that example.
And that would be per person, but the damages might be different for each person based on how they've calculated what their investment was.
That's correct. I mean, there's, the monthly fee that's paid to Matterport, cloud service, that would be part of it as well. So it all adds up. It's just not the investment in the hardware, but it's ongoing monthly expenses for website hosting, for your cloud service plan hosting and all of that would be included in each service partner's damages that they would seek in a case like this.
Okay, I was reading through both complaints, trying to understand, well, okay, what might somebody receive back? So damages, I think we've talked about contract rescission. We've talked about injunctive relief. What would that be?
Well, initially, when we filed the complaint, we were seeking injunctive relief to force Matterport to comply with the disclosure, the registration and disclosure requirements of the 22 states that have the business opportunity sales laws, and prohibit Matterport from further offering the MSP program to new prospective purchasers until they did so in compliance with those particular disclosure and registration laws.
Perhaps that's why Matterport has ceased to offer new enrollments into the Matterport Service Partner Program. So some of us have wondered, well, gee, I wonder why that stopped. So that might be as a result of your filing.
I suspect it is. That's a relatively recent occurrence, as I understand it.
Mhm.
And I believe it started after the suits were filed
Okay.
last year.
Declara- de- declar- Declarative relief?
Declaratory.
Declaratory, thank you. What is declaratory relief?
Uh, the court can make a declaration of the rights of parties. So we would ask the court to make a declaration that the MSP program is in fact a business opportunity or a seller-assisted marketing plan, such that it falls within the ambit of those 22 states' laws.
And why is that helpful to you?
Well, you would get a legal determination that this plan, in fact, falls within the definition of those laws, and therefore those laws applied to the MSP program. And then we would see whether or not they complied with the registration and disclosure requirements. Up to this point, from our Freedom of Information Act requests to each of the states, we have not seen any registration or any disclosures by Matterport that were filed with those 22 states. And so at least up to this point, it appears that they did not comply with any of those requirements of those laws. If that turns out to be the case after discovery, and you have a declaration from the court that the MSP program was subject to the registration and disclosure requirements, then you would have a violation of the law.
And then have damages based on that.
Then the remedies, then all the MSPs in those particular states would have the remedies available to them in the multi-state class.
Could you list the 21 states for us? I'm a Matterport service partner. I'm watching today's show. I hear that there's 22 states that this applies to, California being one of them, but there's 21 other United States. And I could imagine some of our viewers are scratching their head wondering, does this apply to them?
Yeah, sure. Alaska, Connecticut, Florida, Illinois, Indiana, Iowa, Kentucky, Maine, Maryland, Michigan, Minnesota, Nebraska, North Carolina, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Virginia, Washington, and Washington, D.C., and then, of course, California.
Great. So if I'm in one of those other states, do the 2 of the 3 violations apply? The unfair competition law and the false advertising law?
They would. And moreover, because there is the California choice of law provision in the various terms of service and other cloud service agreement, for example, Matterport terms of service, that choice of law provision is in, as we understand it, every contract with an MSP, regardless of what state you're in. It says California law applies. So in addition to the business opportunity sales laws from these 22 states, there would be the 2 California statutes that would apply to all 50 states.
Now I'm totally confused. I was thinking, oh, I didn't hear my state listed out of the 22 states in the United States. Am I eligible as a class member if I am in any one of the remaining states based on
Yeah.
what you just described?
Yes, yes, they are. You can bring different causes of action for the same alleged misconduct. Somebody might engage in misconduct, and that would constitute a violation of one particular statute. It might also constitute a violation of another statute. It might also constitute a breach of contract. It might constitute negligence. There are several different legal theories that can be brought for the same alleged misconduct. And so that's what's happening here. You have a set of facts that are alleged in the complaint, a set of misrepresentations and omissions and other conduct that's alleged in the complaint. And based on those allegations, you have various statutes that are alleged to be violated. So the two California statutes prohibit certain misconduct. And because there is this choice of law provision in the contract that says California law applies, whether you're in one of the 22 states that have another statute that applies too, or if you're not in one of those 22 states, you're in some other state, the two California statutes would apply to you regardless of what state you're in.
Okay. I'm a Matterport service partner. I'm watching today's show. Am I just waiting to see what the resolution of these two class actions are? Am I calling you, emailing you? Am I expressing interest in? How do I be part of, learn more? Help me understand. If, as a Matterport service partner who's watching the show today, what should their takeaway be from today's show?
So we're happy to hear from anybody. We've talked to a number of MSPs and other folks with knowledge, and we're happy to talk to anybody. We're happy to and keep you informed of the case. If you're interested in participating in one of the cases, that's available to you as well. And we'll send you whatever documents, we can. Some things are confidential, but anything that's public, we can certainly send to you. You can go to my website, which is Attorney Zim. It's attorneyzim.com. You could send me an email. It's tom@attorneyzim.com. Could call our office, 312-440-0020. Any of those things, you'll be able to reach us. Our website has a contact form on it. You could submit a contact form and we'll get right back to you.
I'm going to repeat your website again, www.attorneyzim.com, ATTORNEY, Z as in zebra, I as in igloo, M as in Mary, the first three letters of your last name, that's .com. So attorneyzim.com. I noticed on one of the complaints that it's the complaint is not just Matterport, it's the board of director members are named individually. Why is that?
The specific business opportunity sales laws in the multi-state aspect of it for those 21 states provide that not only is the company liable for damages, but that the individual directors are all individually personally liable as well. And so under those causes of action and that particular theory of the case, we name them as defendants because the statutes allow for that.
Only one complaint has the board of director members, though.
Right. The John Stemelin nationwide complaint that we filed in the federal court in California for all of the states except for California, that has them named as defendants, because that's the complaint that has the those 21 different business opportunity sales laws in that complaint.
I see. And I'm thinking about, I'm a real estate photographer. I'm thinking about buying a Matterport Pro 2 3D camera. Scratching my head. What should be my takeaway from watching today's show?
Well, I think you ought to be very careful in your decision making. Hopefully, you understand what you're getting into, what's being promised, and what some of the potential ramifications will be to you and your new business that you want to start with this new program that Matterport has recently introduced, and how that's going to affect you and any business that you hope to get, and any leads that you were expecting to get that maybe you're not going to get because they're going to go to somebody else. So that's the reason why these states require these onerous disclosures, setting forth all of the information that you would need in order to make an informed business decision. And we're happy to talk to you and let you know what the experience is of the two plaintiffs in this case and some of the other MSPs who have contacted us. You can talk to them if you like too, and hear it from them firsthand, and see if you think that it's the right fit for you once you get a different perspective from somebody who's actually living through it.
Both suits ask for a jury trial. Why is that?
Well, we always ask for a jury trial. Everybody's entitled to a jury. And in my experience, trying a lot of cases to a lot of juries, they usually get it right. And we think it's important that when you have 12 ordinary citizens who are hearing the facts that come out at a trial and the testimony of all the witnesses, including Matterport witnesses, and hearing their defense, we believe that it's important for them to decide what is right, what is just, what kind of society do we have. These statutes are there to protect members of the public so that they are not taken advantage of. And most people understand some things happen and it's really nobody's fault. It's just unfortunate. And if that's the case, then that's the case. But people also understand and have in many times personally experienced that there is unfairness that occurs as well. And that there are companies who do take advantage of people. And so it's important to have people with their own experiences sitting there, taking it all in and making their own independent judgment based on their life experiences as to whether this was something that was unfair And if it was, the measure of compensation that should be awarded to the MSPs in order to right the wrong and make them whole and put them back into a position that they should have been in the first place.
To remain eligible as a member of the class, assuming at some point you win, we get a letter that says, hey, the suit has happened. Do you want to participate in whatever the judgment is? Does a Matterport service provider still need to hold on to their camera? Do they need to keep their cloud account active? Or as soon as they cancel their account or return their camera or both, they're no longer eligible?
No, they're still eligible. It depends on the type of relief that would be afforded. Many of these statutes provide that if you're going to rescind the contract, cancel, you have the ability to cancel your contract, that you would have to return the camera and then you would get your refund for what you paid. If you don't have your camera, then there may be other issues that you'll have to face because of that. But I would save everything. I would save all emails. I would save all receipts. Anything that was purchased, if you can, I would save it. Just as Matterport is required to save everything now that they've been sued. Like these scripts that we think exist should not be destroyed. Because in the course of the litigation, we will ask for documents and they will ask for documents and other information. So the more that you have to justify your claim, the better it is. And if you have emails where you've communicated or other writings with people from Matterport, where you believe that they were making statements that ultimately turned out to be untrue, or they made statements and you think, you know what, I sure wish I would have known this other thing, but you never told me that in this email here. And so that would be an omission. You should save all those. That's all very important. And even if you're not planning on participating in the lawsuit as a plaintiff, if you believe that there was misconduct committed and you would like to help your fellow MSPs and trying to obtain some justice and set things right, we would be happy to talk to you and take a look at that.
Tom, in our last 2 minutes here, today is Thursday, August 6th, 2020. What's a likely timeline if this goes all the way to the end to a jury trial? Is this 2 years away? Is it 3 years away?
We're probably looking at a year or two. We're still in the initial stages of the litigation. In the Kenner complaint, that's the California only case, that's a little bit farther along because it was filed earlier. And so we'll be conducting discovery in that case. We'll be coordinating between the two cases as best we can. So if we question a witness, we would have that questioning apply to both cases, so you don't have to question the same witness twice. That will help speed things up. But litigation, it does take some time, especially if you want to be thorough. And I think we're looking at another year or two before, if it goes to a jury trial, it's probably going to take that long.
Is there any question I didn't ask you today that
No, I think that was very thorough on your part too, Dan.
Okay, thank you, Tom. I thank you. I did reach out to Matterport to ask them if they would like to have a show on this topic. I did hear back from them. Thank you for offering the opportunity, but we don't discuss ongoing litigation. So just wanted to let the folks know that we did reach out to ask, did Matterport want to do yet another show on the same topic. Tom, thanks so much for being a guest on the show today. I appreciate it.
My pleasure.
We've been visiting with Tom Zimmerman. He is with the Zimmerman Law Offices, PC in Chicago. Today's topic, Matterport Service Partners class action lawsuit against Matterport. If you missed any portion of today's show, we have been recording it and we will post it in the We Get Around Network forum. If you're watching it on various channels, WGANforum.com, WGANforum.com. Tom, thanks again. And I'm Dan Smigrod, founder of the We Get Around Network forum, and you've been watching WG.